अच्छा मैम, स्टार्ट करें या अभी 5 मिनट बात करें? आप देख लो एक बार, मेरा एक कॉल भी आ रहा है।
5 मिनट्स वेट कर लेते हैं, देन स्टार्ट करते हैं।
अभी ठीक ठीक है, ठीक है, आप बोल दो।
मैं अपने कुछ जो सीए फ्रेंड्स हैं उनको भी सर्कुलेट कर देता हूँ अपने।
हाँ।
फिजिकली कहाँ पे रखते हैं मैम आप प्रोग्राम, आशा जी?
लक्ष्मी नगर में रहता है।
लक्ष्मी नगर में कहाँ पे?
लक्ष्मी नगर, लक्ष्मी नगर में क्रिस्टल बैंकेट है।
हाँ
पीएसके है ना।
हाँ हाँ हाँ, राइट। हाँ,
बस उसी उसी के पास में ही है ये क्रिस्टल बैंकेट।
वंडरफुल। एंड यू आर आल्सो इनटू प्रैक्टिस, राइट?
हम्म।
वंडरफुल।
आपका कहाँ पे ऑफिस?
माय ऑफिस इज इन द्वारका सेक्टर 5. I'm also into practice as a company secretary. So it's been like 6 years plus now.
Okay, that's great.
Totally into secretary and CPE matters. Acha, Asha ma'am, is there any other link also for the participants? Because my colleagues are mentioning that they are not able to join it. I think that link shared with me is just for the panelists.
So they can write that webinar ID and passcode.
Webinar ID and passcode.
Passcode, which you have shared in your message. No?
अच्छा, okay.
You can use that
Okay.
also.
राजीव जी, हाँ आशा जी, मेरे हिसाब से ना इसमें सिर्फ पासकोड है, आईडी नहीं है। तो अगर
सबसे लास्ट में देखिए आपके मैसेज में।
लास्ट में, अच्छा, ओके ओके ओके, राइट, वेबिनार आईडी एंड पार्टिसिपेंट कोड ना। ठीक है, परफेक्ट, ओके, थैंक यू।
तो इससे एंटर होकर के आई थिंक दे कैन रीनेम।
गॉट इट। सो दे विल बी इन द अटेंडी लिस्ट, राइट?
हाँ।
राइट, ओके।
मैं एक बार कंफर्म भी कर लेती हूँ वहाँ पे ना उनसे।
अभी स्टार्ट नहीं हुआ क्या मैडम?
आशा मैडम
हाँ।
कर लीजिए, स्टार्ट कर लीजिए, हो गया टाइम।
संतोष जी आप हैं?
Yes, ma'am.
तो स्टार्ट कर लें हम?
हाँ, start करते हैं मैम. I
हाँ,
think
ठीक
even
है।
16 is also a good number. It's not a.
हाँ नहीं ठीक है, वो स्टार्ट कर लेते हैं। वो
हाँ,
वीडियो
धीरे-धीरे
ऑन
आ
ही थी
जाएगा।
तो आई थॉट कि मे बी शायद कोई कॉल
नहीं नहीं, I am here only. I'm here only.
ओके ओके
For
ठीक है
just 2
राजीव
hours
जी,
I'm
फिर
here only
हम
now.
स्टार्ट करते हैं।
जी मैडम, थैंक यू।
अब 5 मिनट। हाँ, हेमंत जी
करिए मैडम,
हाँ।
आप स्टार्ट करिए।
अच्छा, आपकी तो नेटवर्क सही नहीं है, आपकी वॉल्यूम सही नहीं है। ओके।
प्रोफाइल भी आपके पास है।
बिल्कुल। तो good morning all participants. Welcome to our today's webinar by CA Study Circle, Laxmi Nagar CPE Study Circle. Today we have with us CS Santosh Pandey ji, and he will be deliberating on revival of struck of companies. So welcome CS Santosh Pandey ji. And friends, as a formal ritual, I would like to have to give a brief intro of Santosh ji. He is a practicing company secretary and a law graduate also, and he is having specialization in providing legal opinions and NCLT matters relating to the company law and insolvency and bankruptcy law. He is regularly representing his clients before NCLT and its appellate authority in various high-stake cases. He has also contributed in various active task force committee of the ICSI constituted by the institute for assisting auditing standard board ICSI, secretarial standard board of ICSI, company law committee formed by MCA, and many more. Also in the year 2020, he has been elected as the management committee member of the company secretary benevolent fund of ICSI. He is actively writing on various topics on a regular basis, and his articles are being published on various well-known forums such as Taxman, TaxScan, etc. And he is also regular in taking sessions on various topics under the company law, insolvency and bankruptcy law, legal metrology law, etc. He is also actively holding study circle meetings for the knowledge and growth of the fellow members and professionals. And his motto, and he believed the knowledge shared is the knowledge squared. And one can learn from others and benefit from their experience as well as one's own, and can inherit their wisdom and knowledge therefore. He happily interacts with the positive minded people of all the ages. And at last, even after having such exposure and experience, he still considered himself as a student of law. So with this, welcome Santosh ji. एंड वी आर श्योर कि हम काफी अच्छा लर्निंग एक्सपीरियंस लेकर के जाएंगे यहाँ से. एंड आई रिक्वेस्ट ऑल द पार्टिसिपेंट्स कि इसको इंटरैक्टिव रखें. whatever queries you have, you can write in the chat box or in the Q&A box, or you can raise your hand also, so we can unmute and you can ask your question one to one also. Over to you, Santosh ji.
Thank you so much, Asha ji. Thank you so much, Hemant ji. At the outset, I would like to thank Laxmi Nagar CPE Study Circle of Chartered Accountants for giving me an opportunity to address the learned fraternity on the topic revival of struck of companies. So I welcome you all to this presentation and session. Just I know the profile was a little long, and Asha ji has read the last paragraph very nicely. I believe in knowledge shared means knowledge squared, and I also interact with the people of positive mind people. So I would request you all to please unmute yourself whenever you want to answer any question of mine. And if there is any query, you can ask it during the session also by unmuting yourself. In case you are not comfortable to unmute and you want to post your query, you can post it in the chat box. I will be taking the queries at the end of the session. So I'm looking forward for it. So the first question which arises prior to I will be sharing my presentation with you. The first question arises that why revival of struck of companies has been chosen as a topic, because recently what has happened is that many ROCs, almost I would say all the ROCs, have again issued as a ritual, I would say, since 2016-17 they are rigorously issuing STK 5, STK 7 and STK 1 to the clients, And why this is happening is just because of three reasons. First reason is that the clients are not regularly doing the annual filing, annual return filing, and due to which the ROC is having the impression that company is not carrying on its business or operation, and therefore they are issuing the notice in STK1 form to the company and the director, so that if they are having any intention to run the business, or they are into business but they are not able to do the compliances, they can come forward and tell to the client. Second reason is from the professional point of view, they are not paying us, and that's why we are not able to work for them, and they are not having professional guidance, which they usually mention in their company appeal. So for understanding revival of strike of companies, directly going to that particular point, it won't be justifiable until or unless you are not understanding the provisions of strike off. What does the strike off provision? What are the powers with ROC, and how the strike off happens by the ROC? What is the procedure which they follow? What is the procedure in case the company has voluntarily moved the application for the strike off, and later on after 2 years, 3 years, 4 years, they are realizing we have to do operations of business into that particular name, and I want to revive that particular company. So what are the provisions for that? Also, we will be understanding it. I will be just sharing my screen with you. This is my presentation. Asha ji, please confirm if you are able to see the screen.
Yes, visible.
Okay, so though the topic has been given to me is revival of strike of companies, I will be starting with the understanding of strike of provisions, because once you get to know about the strike of provisions in the technicalities, then only you will understand how the revival happens. Also, the intent to give the presentation on this particular point is that you all are our chartered accountant fellows, so you can also deal with these matters of revival before the NCLT. Before the NCLT, any professional can appear, even if it is a chartered accountant or a company secretary. So my intent will be to motivate you, to make you understand that whenever you take the matter before the NCLT, honorable NCLT, so how you have to appear before that particular tribunal, and what are the points you have to keep in mind while making the appeal, and what are the grounds on which you can seek the revival of this strike of companies. So prior to moving forward, I just want to give one disclaimer that whatever opinion I will be giving in the presentation will be strictly personal, and the opinion may differ depending upon the case to case. So do not interlink my opinion as a concrete opinion for your case. I will be discussing with certain questions which are general standard questions, which generally comes while dealing with the revival of companies, strike of companies. So I will be dealing with that particular questions by referring to certain case laws in the presentation. So I would request you all to please keep that in mind. Moving forward, so what we'll be covering is, there is a huge list. First one is, I will let you know strike off hota kya hai, what is strike off. फिर मैं आपको बताऊंगा what are the kinds of strike off, strike off कितने kind के होते हैं. थर्ड मैं आपको बताऊंगा what are the grounds for strike off, on which ground the ROC can strike off the company, on which ground the company can move the application voluntarily for the strike off. Fourth one, I will be letting you know the procedure for removal of name if the action is taken by ROC. अगर ROC कोई action लेता है, तो ऐसा तो है नहीं कि उनको दिखा कि हाँ 2 साल की फाइलिंग नहीं हुई और डायरेक्टली आपको एक strike off notice भेज दिया that your company has been striked off. Whether that happens or there is a particular procedure for it, I will let you know. Fifth one will be the circumstances in which ROC also cannot take action. किन circumstances में ROC action ले ही नहीं सकता, ये भी मैं आपको बताऊंगा. Sixth one will be क्या प्री रिक्विजिट्स हैं, क्या क्या रिक्वायरमेंट है अगर आप STK2 मूव कर दे, दैट इज वॉलंटरी स्ट्राइक ऑफ कंपनी खुद ही जाती है, बोलती है मेरे को कंपनी बंद करनी है और वो STK2 फाइल करती है, तो क्या क्या प्री रिक्विजिट्स है, आई विल लेट यू नो. देन आफ्टर सर्कमस्टेंसेस जिसमें कंपनी वॉलंटरली भी नहीं जा सकती, वो भी मैं आपको बताऊंगा. फिर मैं आपको बताऊंगा इफेक्ट ऑफ स्ट्राइक ऑफ क्या है. Then brief about the disqualification. I won't go into the technicality of disqualification, vacation and deactivation, but I will let you know whether it is a legal entity, having the legal entity in case of a strike off or not. That I will let you know. 10th will be the consequences. कई बार आपने देखा होगा कि एप्लीकेशन मूव करते समय क्या होता है कि 1 साल पहले तक ना रेवेन्यू था, लेकिन बहुत मिनिमल रेवेन्यू था, 10,000 15,000 था, बैंक अकाउंट भी नहीं खुला था, कैश में काम चल रहा था. अब क्या होता है कि हम लोग प्रोफेशनल, एज अ प्रोफेशनल हम लोग क्या गलती कर देते हैं कि हम लोग ना STK2 बनाते समय नील रिटर्न बना देते हैं कि कौन देखने आ रहा है. So in case you move that application and tomorrow ROC gets to know, so what are the consequences? Because that application will be a fraudulent application, honestly speaking. So what are the consequences if the ROC gets to know or anyone complains regarding it? Then after I will come to the main topic of my session, that will be the appeal to the tribunal for revival. Differences I will let you know. There are two sections. I will subsections in the 252. I will let you know the differences between them. Grounds for revival on just ground. Suppose your company is not having revenue. Suppose your company is not having any operations. Now you want to revive the company. So what can be the just ground? Just ground means what is justifiable grounds. How you have to convince the honorable tribunal. 14 will be कि आप जब अपील फाइल करेंगे तो आपके क्या क्या प्री रिक्विजिट्स होने चाहिए. एंड देन अगर आपको ऑनरेबल एनसीएलटी से कुछ ऑर्डर फेवरेबल नहीं मिला है, एडवर्स ऑर्डर, तो आप अपील कहाँ पे करेंगे. एंड लास्ट में मैं आपके साथ कुछ इंपॉर्टेंट केस लॉस को कवर करूंगा. तो अगर मैं स्ट्राइक ऑफ की बात करूं, so in simple sense it means the removal of the name of the company from the register of companies by the ROC or on the willful I would say action of the company. Suppose company wants to move the application, wants to strike off itself, they can move the application, or ROC can also strike off the company depending upon the reasonable cost of belief. If you read the provisions of section 248, it starts with when the ROC has the reasonable cost to believe. It's something like they cannot even also not strike off on their own whims and fancies. They have to have the reasonable cause behind having the presumption that the company is not into operation of business. Like for example, I will let you know. Suppose Reliance Industries Limited is a company which is run by Mukesh Ambani ji. Tomorrow, sometime due to some technical error, suppose that company was not able to file AOC for NDT7 for say 3 years or 2 years. So on the basis of that, ki AOC for NDT7 file nahi hua, whether ROC can strike off Reliance Industries Limited, presuming that Reliance Industries Limited has not been into operations. The answer is clear no. Because in the market, Reliance Industries is totally into operations, so they cannot have the reasonable cause to believe that Reliance Industries has not been in operations because annual filing. So annual filing is just the intimation of the financials, which is prescribed under 137. That cannot be the biggest rationale for determining whether the company is into business or operation. So first thing, for understanding the reasonable cause of to believe that the company is not in operation, I have given you the best example of it. So ROC must have the reasonable cause that yes, on the basis of this and this act, I am presuming that a company is not into operations. So this will be the matter of strike off. Also, strike off cannot happen on any ground. There are certain specific grounds of it which are mentioned under section 248, which we will be discussing in our presentation later. Now, there are two types of removal. First one is 248 subsection 1, which is the action taken by the ROC. Second one is 248 subsection 2, in which the action is not taken by ROC, rather company moves the application voluntarily. So I will be discussing with these two types of strike off and what are the technicalities therein. Now, for any kind of strike off, these are the grounds. First ground is that the company failed to commence the business within 1 year of incorporation. आपने incorporation से 1 साल तक काम नहीं करा. अगर आपने काम नहीं करा, commence नहीं करा business, तो आपको strike off कर सकते हैं. Second, या आप खुद भी move कर सकते हैं application. Second, आपने सपोज आपकी कंपनी इनकॉर्पोरेट हुई थी 2015 में, आपने 2017-18 तक तो काम किया, बट 19-20-20-21 तक काम नहीं करा, काम कुछ भी नहीं हुआ 2 सालों में, लास्ट 2 इयर्स में, तो भी आप खुद भी स्ट्राइक ऑफ के लिए मूव कर सकते हो, या आप कहते हैं आरओसी के थ्रू भी स्ट्राइक ऑफ हो सकते हो. थर्ड वन इज जो आपको अभी रिसेंटली मार्केट में बहुत दिखता होगा जब आप नई कंपनी इनकॉर्पोरेट करते हैं, दैट इज सब्सक्राइबर्स आर नॉट पेइंग मनी विद इन 180 डेज. अगर 180 दिन में आप पेमेंट नहीं कर रहे हो, मनी सब्सक्राइबर सब्सक्रिप्शन मनी नहीं दे रहे हो जो आपने प्रॉमिस किया था इन द एमओए टू पे, देन and you are not filing the declaration also in INC 28, then also they can strike off. See, so two things has to happen. First one is the subscription of money has to be received. Second one is the INC 20A has to be filed. Suppose you have received the application money and you have not filed INC 20A, then also ROC can send you the notice. Then you have to justify that we have put the money. Suppose you have not put the money, but you have filed the INC 20A by attaching something, some random PDF into it. So it does not mean that since it is a STP mode form, it might be the possibility you might get the approval of it also. It does not mean that you are complying with the subsection 3 also. So you have to particularly meet both the criteria. Put the subscription money into the bank account of the company and also file INC 28. That should be the legal documents. Fourth one is, suppose you are having the registered office. आपका registered office है company का, और आपने उस registered office में suppose कोई notice आया ROC से और वो receive नहीं हुआ, it went back to ROC again. Then if the ROC do the physical verification of the registered office and they get to know that this company is not having any business or operations here, so then also that company can be striked off by the ROC, or even you can move the application by your own. Suppose you also want to say that we are not having any registered office, we are not willing to move forward. So on this ground also you can move the application under STK 2. So these are the grounds of strike off for any kind of strike off. Asha ji, just do let me know if I am going correctly. If I'm not going fast, also just let me know if I am understandable.
Yes, understandable. And I don't seem to be a fast. Just a small request. Just a small request. If you can put it in a slideshow mode, view slides.
This is a slideshow mode now.
But okay, maybe my setting issue. Okay, please continue. I will check my settings then.
No problem.
Okay.
It is a slideshow.
Okay. Please.
Right. And do let me know, ma'am, whenever there is any query from the participant, do let me know. I would love to answer it.
Yes, sure.
Right. Now, the question comes whether STK2, sometimes what happens is, आपको दिखता होगा जैसे कंपनी आपने नई बनाई, इनिशियली जब कंपनी बनाते थे तो दो भाई आते थे और वो बोलते थे ये मेरा दोस्त है, ये मेरा भाई है और मैं कंपनी बना रहा हूँ इसके साथ, एंड आई वांट टू पुट मनी इनटू दैट कंपनी. जब कंपनी इनकॉर्पोरेट होगी, टर्म्स एंड कंडीशन उनकी आपस में मैच नहीं कर रही, माइंडसेट उनका मैच नहीं कर रहा है, दे आर नॉट पुटिंग मनी इनटू इट. सो whether you can move application in STK2 for the strike of that company, then the answer is yes. Two things has to be met. Subscription money ना आई हो और 180 दिन lapse हो गए. So if that is the very basic question which is revolving in the market, so I would like to answer it. You can file the application in STK2. Suppose your subscription money has not been paid by the subscriber, so you can do it voluntarily by the shareholders. Now coming to the procedure. अब मैं पहले ROC का प्रोसीजर समझाऊंगा. जैसे ROC जब भी स्ट्राइक ऑफ करता है तो क्या प्रोसीजर वो फॉलो करते हैं. Before taking this particular concept, I would like to give the disclaimer that 248 and 252 is not well drafted. In my view, in my knowledge, it is not well drafted. Also, there are certain lacunas or not clarity, I would say, in the procedure to be followed. So their language is somewhere ambiguous. So being in the so I will be dealing with the 240 and 252 from the practical point of view and the legal point of view, both mix. So just be with me on that particular point. So first is, जैसे ही उस कंपनी को किसी भी ग्राउंड में ROC को लगता है कि that company is not into business or company is not maintaining a registered office or the company has not received the subscription money, it will issue STK1. STK1 will be issued specifically to the company and the directors, not to anyone else. So that is the intimation by the ROC to intimate to the director and the company that they are going to remove the name of the company. And they give the chance to the director and the company to file the reply. The chance given is of 30 days. Second question, suppose you do not file the reply within 30 days or you do not file the satisfactory reply within 30 days, they will publish STK 5 on the MCA, official gazette, and into the English and vernacular language newspaper. Two newspapers, one is English and the vernacular language newspaper. In the newspaper, they will be publishing it in STK 5A. Now, if you will refer to the provisions of 248, it says that this will be for the general public. Now, the general question comes that whether, suppose the director and the company have failed to file the reply to STK 1, whether they can file the reply to STK 5. What is the practical situation? I would like to quote unofficially and off the record. What is the practical problem which I get to know from my fellow colleagues in the market? That when they went to file the reply of STK 5 to the ROC, ROC, some of the officials were not interpreting it in the proper manner, and they said that no, you are not having the power, being a director of the company, you do not have the power to file the reply to STK5, because the chance was given to you in STK1. STK5 is for general public, not for company and directors. So I will let you know that particular concept, whether they are having the right interpretation or not. But suppose if you will not file the reply to STK5, or someone from the general public does not file any reply to STK5, then ROC will be publishing STK7 and your company will be struck off. Your company's status will be changed from active to under process of strike off and company stands dissolved. When the STK5 is issued, the status gets changed from active to under the process of strike off. Active से under the process of strike off आपको दिख जाएगा. Now the question comes, suppose आपने STK1 का रिप्लाई नहीं करा, तो क्या आप STK5 का रिप्लाई कर सकते हो? The answer is yes. See, intention of 248 is not that they have to strike off the company. They have to strike off each and every company which is not filing the annual return. That is not the intention of 248. The intention of 248 is to strike off those shell companies which are not actually doing any business. That is the intention. So even if you file the reply to STK5 and you have not filed the reply to STK1, the ROC department is bound to take that reply on record and take necessary action in that regard. So you do not have to particularly follow up also indirectly through indirect means. You do not have to follow up. You just file the reply legally at the office of the registrar of companies and just do the normal follow up that we have filed the reply, what you are doing. So you will get the status change from under the process of striking off to active. So that will be the first answer to this particular question. Abhi market mein STK5 bahut issue ho rakhe hai. So even if some of your company has not received STK1 or have failed to file the reply to STK1, you are having the chance to file STK5 reply. So please do that. Now, circumstances in which strike off cannot happen. किन ग्राउंड्स में स्ट्राइक ऑफ नहीं हो सकता, चाहे वो आरओसी करना चाहे, चाहे वो वॉलंटरली कंपनी मूव करना चाहे. फर्स्ट वन इज लिस्टेड कंपनी. अगर कोई लिस्टेड कंपनी है तो स्ट्राइक ऑफ नहीं हो सकता. सेकंड वन इज डी लिस्टेड कंपनी. लेकिन हर डी लिस्टेड कंपनी नहीं, वही डी लिस्टेड कंपनी जिसने डीलिस्टिंग करते समय डीलिस्टिंग जो हुई है वो उसकी नॉन कॉम्प्लायंसेस की वजह से हुई है. अगर वो compliant था and voluntarily did the delisting, that can be striked off. There is no difficulty. Third one is the vanishing company. Vanishing company has been explained in the rules explanation that the company which is a listed company, it cannot be any other than company other than listed company. It has to be listed company. First, it is a listed company. It has not complied with the listing provisions and the directors of that particular company is not traceable. So these are the three conditions which has to be met for vanishing. Fourth one is companies against which inspection or investigation is pending or has been ordered or has been carried out or is about to be carried out. Fifth, investigation has been completed but the prosecution is yet to be started or is pending before the court. Sixth, notice for inquiry or scrutiny, not inspection. Inspection investigation is the later stage. Notice for inquiry and the scrutiny has been issued and reply is yet pending on that particular matter. So even if the notice of inquiry or scrutiny has been issued and satisfactory reply has not been made or the reply is pending to be made, then also strike off cannot happen. Seventh, prosecution is pending before any court. Prosecution is pending before any court. Eighth, now the language of the section or the provision is compounding application is pending before competent authority. So now there are two interpretations. पहली चीज ये competent authority Companies Act के हिसाब से ही होगा, या तो RD होगा या फिर NCLT होगा. My answer to it is that we should read it in a more wider manner because they are not using the competent authority under the law. Neither the competent authority has been defined under the Companies Act. So from my understanding, it will be compounding application which is pending before any competent authority. Suppose you are not moving the compounding application before Companies Act and you are moving the compounding application before criminal court, then also that company cannot be striked off. Ninth is that the company have accepted public deposits. कोई public deposits company ने लिया हुआ है तो वो strike off नहीं हो सकती. 10th is company के पास charges हैं जो अभी satisfy नहीं हुए. कंपनी के पास चार्जेस हैं जो अभी सेटिस्फाई नहीं हुए हैं तो वो कंपनी स्ट्राइक ऑफ नहीं हो सकती. 11th and foremost is the important, section 8 companies cannot be striked off. So if you want to strike off the section 8 company, you have to first surrender your license of section 8 company, you have to convert it into the normal private company, and then after you can file the strike off of it. Am I clear, Asha ji?
Yes.
I will be disturbing you again and again because I think
not an issue, not
yes,
an issue.
yes,
I am here only.
Thank you so much for being there. Thank you so much. Okay. Now coming to the voluntary removal. When the company wants to move the application voluntarily, then what are the points which they have to keep in mind? So the language in front of you is the language of the section itself. So I will be decoding it in the in my language. So the first thing is you have to extinguish all the liabilities. It is starting with the phrase without prejudice to the provision of subsection 1. It means STK 2. Suppose you are filing the application of STK 2 and STK 1 has been issued. The action taken by ROC cannot be prejudiced. Cannot be prejudiced. Their action will be supreme. So first thing is that. Second is a company may, after extinguishing all the liabilities, it means the first foremost requirement is that you have to extinguish all the liabilities. There cannot be any liability. Suppose any liability is there and you are not having business, not having operation, liability is standing there, then also you cannot move this application. Then after, by a special resolution. So you have to obtain the special resolution in the general meeting. Suppose general meeting is not happening, then you can also get the consent from the 75% members in terms of the paid up capital. आप return में consent ले लो 75 members of 75 members से, so that will also suffice the purpose. You do not need to hold the general meeting. Then after you have to move the application, and application can be moved on any of the ground. जो अभी तक हमने ground पढ़े थे कि कंपनी ने ऑपरेशन नहीं करा है इनकॉर्पोरेशन से, या कंपनी बिजनेस में नहीं है 2 years से, या कंपनी ने सब्सक्रिप्शन मनी नहीं दिया, या रजिस्टर्ड ऑफिस मेंटेन नहीं हो रहा है, तब क्या कहते हैं आप, यही ग्राउंड में से कोई एक ग्राउंड ट्रिगर हो रहा है तो आप STK 2 मूव कर सकते हो. एंड अगर कोई कंपनी स्पेशल एक्ट के अंदर है, जैसे फॉर एग्जांपल NBFC दैट रिक्वायर RBI रजिस्ट्रेशन और लाइसेंस, so that NOC, that approval from that particular regulatory authority has to be maintained. Suppose your company is a web aggregator and they are obtaining registration from the insurance IRDA authority, so you have to get the approval or the NOC from the IRDA authority as well. Similarly, the list has been given under that. I'm not going into that particular list. So you have to get the approval from that particular regulatory body. Now, what are the attachments to STK 2? First one is the indemnity bond. You have to attach the indemnity bond by every director, that even if the liability comes in front after the strike off is approved by the ROC, then the director will be personally satisfying or satisfying that particular claim. So that will be the indemnity bond which will be provided by the director. In case of government company, unfortunately, if any government company gets striked off, then that company's authorized representative, which should not be below the rank of secretary, will be giving same indemnity bond under the form STK 3A. That is a specific form for the government. Third one is statement of accounts. You have to file the nil statement of accounts in STK 8. Even if suppose you are not able to file the nil statement of accounts, you have to show the losses statement of accounts. It can be in losses, but you should not be in operation. That should be the declaration given by the directors. For that, affidavit by all the directors in STK 4, that is the statement given by directors that they are having all consensus to file this application in STK 2, and there is no fraud, there is nothing and all. They have to file that particular affidavit. You have to attach the special resolution as already discussed on the consent of the 75% of the member, and you have to particularly give the statement that there is no litigation pending. कोई litigation हमारी company में pending नहीं है. You have to attach that statement also to the particular STK 2. Now, one more document which is going in the market is the chartered accountant certificate that the company is not having turnover. That document has not been asked legally in the law, not in the provisions, but I have heard that that has been asked in the help kit of STK 2. So that is not, I would say, that is challengeable to be challengeable to be asked. So you can argue on that particular point, but instead of going into arguments, if the company is going into a strike off, I would say you can definitely give that state document also, because ROC is always having the power to ask any document. So chartered accountant certificate, if the turnover, the company is not having any turnover in the previous 2 years, that has to be specifically given into that STK2. I have not added into this list. I am just telling you it verbally for your knowledge. So these are the documents which you have to attach to the STK2. Now, on which ground STK2 cannot be made? First one is all the grounds which were mentioned earlier: listed company, vanishing company, Section 8 companies, prosecution pending, compounding. On that ground, you cannot move the application of STK2. In addition to that, suppose you have not filed AOC for MDT7 up to the last financial year, in which the company has ceased to carry on its business. अब आप मार्केट में क्वेश्चन देखोगे जो आपके सामने भी आते होंगे कि सर STK2 फाइल करने से पहले क्या AOC for MDT7 की compliances हर साल की करनी जरूरी है? So the answer is clear no. Answer is you have to file AOC for MDT7 up to the time, up to the financial year जिसमें आपने कंपनी का बिजनेस ऑपरेशन सीज कर दिया था. सपोज आपने 2017 में सीज कर दिया था, तो आप 2017 तक की फाइलिंग करोगे. 18, 19, 19, 20, 20, 21, 21, 22 की फाइलिंग करने की आपको जरूरत नहीं है. आप डायरेक्टली STK2 फाइल करिए और एक डिक्लेरेशन दिए दैट वी आर नॉट इनटू बिजनेस फ्रॉम सिंस 2017 and we have filed the return till 2017 as per the law. So that is the clear cut legal answer. Second is, suppose ROC ने आपको STK1 इशू कर दिया, आपको रियलाइज हुआ यार ROC ने STK1 इशू कर दिया है, अब ये स्ट्राइक ऑफ करेगा और ये मेरे दिन को डीएक्टिवेट करेगा. So instead of getting that strike off through that route, मैं ही STK2 फाइल कर देता हूँ. So that is also not the possibility. You cannot file STK2. If you want to file STK2, you have to get first that STK1 cancelled, then only you can file STK2. Third one is, suppose STK7 issue कर दिया, strike off कर दिया, then also you cannot move STK2. आप move कर भी नहीं सकते technically because वो strike off हो जाएगा तो form fill नहीं होगा. But again, due to any technicalities, you are able to file it, then also you cannot file it. Now, in last 3 months, suppose you have changed the name of the company. अगर आपने कंपनी का कोई नाम चेंज किया है तो आप क्या कहते हैं स्ट्राइक ऑफ एप्लीकेशन नहीं मूव कर सकते. सपोज आपने रजिस्टर्ड ऑफिस शिफ्ट किया है एक स्टेट से दूसरे स्टेट में, तो आप स्ट्राइक ऑफ नहीं कर सकते. आपने सिटी में चेंज किया है, विद इन द सिटी है या विद इन द स्टेट है, दैट्स फाइन. आप वन स्टेट टू अनदर जा रहे हैं तो आप स्ट्राइक ऑफ नहीं कर सकते. सपोज कोई कॉम्प्रोमाइज अरेंजमेंट का मैटर है बिफोर द NCLT, then also you cannot file that particular STK2. Suppose company already binding up order has been passed by company under Companies Act और IBC. अगर binding up order pass हो चुका है तो भी आप STK2 फाइल नहीं कर सकते. Suppose the company is engaged into any other activity, not the main object activity or not in the activity which requires the closure of that particular company, but some other third activity, then also you cannot file the STK2. Suppose you are disposing any property of yours to gain the value of it, because after strike off मैं property बेचने जाऊंगा तो वो possibility नहीं होगी. लिक्विडेशन में नीलामी की रेट बहुत कम होते हैं तो मैं आज ही बेच देता हूँ. So that also you cannot do in last 3 months. अगर आपने ये किया है तो वो नहीं allowed होगा. So that is the circumstances in which STK2 cannot be moved. Now, going for the effect of strike off, just allow me to attach my charger to my laptop. 1 second. 1 second. Yes, so coming for the effect of strike off, that is section 250. This says that suppose the company has been striked off. अब strike off होगी तो क्या होगा? कंपनी कोई बिजनेस नहीं कर सकती. Now company cease to operate. First thing. And it may be the possibility that after the strike off, your bank account is also getting freezed. Suppose it is not getting freezed and the company is strike off and you are doing the transaction from that particular bank account, then it will be leading to siphoning of funds. It won't be correct. It will be a fraud. So you cannot do any transaction with this strike off company. Second is that a certification of incorporation of the company shall be deemed to be cancelled. जो certificate of incorporation मिला था वो cancel हो जाए. Third one is that it will be considered dissolved for all the purposes except 2 चीजें. जो कंपनी को रिकवरी करनी चाहिए थी वो नहीं हुई, और जो कंपनी को पे करनी है लायबिलिटी उसके लिए वो हमेशा एक्टिव ही मानी जाएगी। इन दोनों चीजों के अलावा वो सब चीजों के लिए डिसॉल्व हो जाएगी, ऑपरेशंस के लिए डिसॉल्व मानी जाएगी, सब चीजों के लिए डिसॉल्व। So that is the decoding of section 250. Now, just brief about the disqualification vacation. What are the disqualification provisions? Says that suppose the company is not filing the annual return or the financial statement for last 3 financial years, then the director will not be qualified enough to get appointed or reappointed into any particular company. That is the provision of 164 subsection 2. 167 subsection 1 says, suppose any director, कोई डायरेक्टर डिस्क्वालीफाई हो जाता है 164 में, तो वो उस कंपनी में, जिस कंपनी की वजह से वो डिस्क्वालीफाई हुआ है, उस कंपनी को छोड़ के बाकी सारी कंपनी से वो वेकेट कर जाएगा। सो डिस्क्वालिफिकेशन वेकेशन गो हैंड इन। नाउ रूल 11 ऑफ द कंपनीज अपॉइंटमेंट एंड क्वालिफिकेशन ऑफ डायरेक्टर रूल्स। यहाँ पे कुछ पावर दी गई है और उस पर जिन ग्राउंड्स पे वो डिन को डीएक्टिवेट कर सकते हैं। नाउ द आयरनी इज this does not have the power to deactivate the DIN in case of strike off rule. Suppose the ROC is striking off and feeling like disqualification is happening, then it cannot deactivate in rule 11. That's why if you will see, you must have observed that lot of writs has been filed before the High Court that ROC is not having the power to deactivate DIN in case of disqualification. They are not having the power. So that is quite challengeable. That is still under consideration, and now I think the situation is also clear that it is not having the power, so they cannot deactivate DIN as such. So you can file the writ petition before the High Court for seeking necessary directions and interim relief on that particular point. So that is all about disqualification. Now, I have discussed earlier that suppose you are moving an application where the company has had the little bit of income of say 20,000, 25,000, and you are moving the application showing it as nil and saying that the company was not having any operation, any business and all, then that application will be considered as fraudulent application. Suppose the company is having liability of 10,000 rupees even, and you are moving the application that there is no liability, because ROC will be relying on your application, on your documents. And after the strike off, if ROC gets to know there is a liability of even 1 rupee, then also that is not a proper application, that will be considered as fraudulent. So what is fraudulent is where the objective of the moving the application is to evade the liabilities. You are going to evade the liability of someone, or you are going to defraud the creditor, you are going to breach the trust of the creditors or any other person. किसी और बंदे का भी आप trust या defraud करते हैं तो भी वो fraudulent माना जाएगा. Now the beautiful language which has been used in that particular section is who will be liable. They have not used the word director. They have not used the word promoter. They have not used the word members. They have not even used the word company. They have used the word the person in charge of the management. Suppose tomorrow there is director and there is also one person who is having the charge of the management affairs and writing. Then that person can also be dragged into the consequences. That person can also be considered as doing the fraud with the members or the creditors or the persons outsiders. Then he can also be liable. So the person in charge of the man, whosoever it is, he will be liable. Third one is, what are the consequences? Suppose अब तो fraud तो कर दिया आपने, application ऊपर से strike off कर दिया. You will be punishable under 447. Prosecution can be launched against you under 447. And prosecution can be recommended by you, by the registrar against you also in any court. So you have to be very, very cautious while moving the application in STK 2. This section is strictly restricted to STK 2 because it is starting with an application by a company under subsection 2 of 248. 248 subsection 2 was the company moving the application by itself. So this is all about 251. Now I have given you the example of fraudulent act also, showing liabilities as nil. Now moving forward, like suppose this is a section of appeal to tribunal. Now you want to move the application for appeal. Now appeal to tribunal for revival. There are two sections, 252 subsection 1 and subsection 3, which are having biggest of ambiguity in themselves. So I will be letting you know my interpretation on that particular point, and I hope you will be agreeing with my interpretation also. So the starting of 252 subsection 1 starts with a very general language, that is any person aggrieved. It means कोई भी, चाहे वो कोई भी हो. Any person agreed by an order of the registrar. Now the language is कोई भी व्यक्ति किसी भी तरीके से aggrieved है किससे? Order of the registrar से. It means it is dealing with the cases where the registrar has passed the order notifying a company as dissolved under 248. That person may file the appeal to the tribunal within 3 years. कितने दिन में फाइल कर सकता है? 3 साल में फाइल कर सकता है. किस दिन से? जिस दिन से रजिस्ट्रार ने ऑर्डर पास किया था. और अगर आरओसी को लगता है या सॉरी ट्रिब्यूनल को लगता है कि जो रजिस्ट्रार ने पास किया ऑर्डर इट वाज नॉट जस्टिफाई इन द एब्सेंस इन व्यू ऑफ द एब्सेंस ऑफ द ग्राउंड, जो 4 ग्राउंड हमने डिस्कस किए थे वो ग्राउंड एक्चुअल में है नहीं, जैसे कंपनी आरओसी को लगा कि वो ऑपरेशंस में नहीं है बट आप प्रूव कर दो ऑपरेशंस में है, देन ट्रिब्यूनल आपको रिवाइवल ऑर्डर पास कर. नाउ डिकोडिंग 252 सबसेक्शन. When the appeal can be filed, when someone is aggrieved, who is having right to file the appeal? Any person. Also, if you observe the proviso of 252, it is giving the power to ROC also to file the application. अगर ROC को strike off करने के बाद लगता है कि उसने गलती कर दी, then also ROC can file an application before the tribunal कि मेरे से गलती हो गई, मैंने सोचा ये कंपनी ऑपरेशंस में नहीं है लेकिन ये कंपनी एक्चुअल में ऑपरेशंस है, ये मेरे नॉलेज में आया, दैट्स व्हाई आई एम मूविंग दिस एप्लीकेशन. थर्ड, व्हाट इज द टाइम लिमिट टू फाइल द अपील और एप्लीकेशन? दैट इज 3 years. Fourth, when the tribunal will allow the appeal, when the tribunal opines that striking off is not justifiable. मतलब आपने जो ग्राउंड्स जिस ग्राउंड्स में इस कंपनी स्ट्राइक ऑफ हुई है वो जस्टिफाइबल नहीं. To whom the reasonable opportunity of being heard will be given, that is the registrar and all person concerned. Now presently registrar and all person concerned, what NCLT is doing is they are asking to make the registrar of companies and the income tax the party. I'm not able to understand the rationale behind making the income tax authority the party to the petition, because whatever income tax authority have to say, even if income tax authority wants to take any action against the strike of company, that can be done after the company is getting revived. So I have observed personally that income tax authority itself is moving the application under 252 subsection 1 for getting the revival of the company. So I am not able to understand why honorable NCLT is asking us to make the income tax a party, and there is no strict requirement of it. So I think I am hoping that honorable NCLT will be waiving off with this particular condition, and we have to make the ROC only the party. Yes, I can say RBI. Suppose RBI have to be made party, then RBI have to be made party. It can be done. Suppose the NBFC company is moving the application, RBI can be made party if required. So that can be the rationale, but not the income tax authority. Now 252 subsection 2. Now this is I would say the biggest section which must be implemented, but it is not getting implemented, and I will let you know the reason of it. It says अगर कोई revival का order pass होता है तो कंपनी को वो ऑर्डर 30 दिन के अंदर फाइल करना है टू द आरओसी, एंड आरओसी को उसके बाद एक फ्रेश सर्टिफिकेट ऑफ इनकॉर्पोरेशन देना. मतलब अब आपका एक फ्रेश सर्टिफिकेट ऑफ इनकॉर्पोरेशन इशू होना चाहिए. बट द क्वेश्चन कम्स, क्या वो एक्चुअल में हो रहा है? सो द आंसर इज नो. आपको उसका रीजन बताता हूँ. क्योंकि जैसे ही वो फ्रेश सर्टिफिकेट ऑफ इनकॉर्पोरेशन देंगे उसका डेट ऑफ इनकॉर्पोरेशन आज का हो जाएगा, फिर आप पीछे की बैकडेटेड फाइलिंग नहीं कर पाओ, आपकी सारी फाइलिंग वेव ऑफ हो जाएगी. तो आपको आरओसी की जो फीस आनी थी, अच्छी खासी स्टैट्यूटरी फीस और गवर्नमेंट को जो एडिशनल फीस आनी थी, वो सब खराब हो जाएगी. दैट्स व्हाई दे आर नॉट इशूइंग सर्टिफिकेट ऑफ इनकॉर्पोरेशन एज पर माय नॉलेज, व्हिच अदरवाइज इट इज अ वेरी चैलेंजेबल ग्राउंड दैट यू शुड गिव द सर्टिफिकेट ऑफ इनकॉर्पोरेशन, फ्रेश सर्टिफिकेट ऑफ इनकॉर्पोरेशन. सो दे आर नॉट गिविंग इट प्रेजेंट. नाउ मूविंग फॉर 252 subsection 3. Now under 252 subsection 3, only few persons can move the application. It is not like 252 subsection 1 ki anyone can move the application. And the word used here is the application. In 252 it was, yes, am I yes, Rajiv ji, are you saying something? Maybe some technical glitch. So under 252 subsection 1 it was appeal. Under 252 subsection 3 it is application. So the language used is under 252 subsection 3, only 4 persons can move the application. First one is the company, second one is the member, third one is the creditor, fourth one is the workman, which feels that feels agreed by the company having its name struck off. मतलब कंपनी ने एप्लीकेशन खुद लगाई थी STK 2 में, कंपनी ने अपना नाम स्ट्राइक ऑफ करवाया था from the register of companies. So it is dealing with the cases of 248 subsection 2 indirect. What is presently practically happening is that the members are moving the application in 252 subsection 3, not the application appeal, and they are saying that we are having a limitation of 20 years. If that is the intent, then what is the use of 252 subsection 1 जो 3 साल की बात करता है? फिर उसका मतलब ही क्या रहेगा? 20 साल की लिमिटेशन हो जाती. So just to decode 252 subsection 3, on what ground revival is possible, and also any ground, that can be any ground that the company is carrying on business or operations, and it is just ground can be taken, that the company is having the justifiable grounds that it should be given chance, even if the company is not having operations or business in the past. Second, कौन move कर सकता है application? Member कर सकता है, creditor कर सकता है, workman कर सकता है, workman कर सकता है. Now the question comes, company कैसे करेगी? Company तो strike off हो चुकी है. Now company cannot pass board resolution, company cannot authorize any person to appear, company cannot be a party to the petition. It can be performer party, it cannot be the main party to the petition. So I'm not able to understand. That's why I said in the beginning that 252 and 248 is not well drafted. So even if the company has to be revived, that application will be moved through the member or the creditor or the workman. In under 252, any other person. But company cannot be a party to the appeal and moving an application or the appeal for the revival of its own. It cannot be the possibility. Now, what is the time limitation under 252 subsection 3? That is 20 years. Suppose you move the STK 2 and ROC strikes off. And later ROC gets to know that you have not given the proper document and it has been inadvertently approved by the ROC, and ROC is having the view now that the company was in operation. Then for that, ROC is having the limitation of 3 years under 252 subsection 1. For you, for the company under 252 subsection 3 is 20 years. What will be the effect of order of tribunal? Now the language use is different. Under 251, it was the fresh certificate of incorporation will be issued. Now here the language is that your name will be restored in the same position as if the name has not been struck off at any point of time. It means you will not be issued fresh certificate of incorporation under the cases where you are moving the application by your own. STK 2 अगर आप मूव कर रहे हो, आपको फ्रेश COI नहीं मिलेगा. लेकिन अगर आप क्या कहते हैं ट्रिब्यूनल से 252 सबसेक्शन 1 के अंदर ऑर्डर ला रहे हो, ROC का अगेंस्ट जाके और ROC के ऑर्डर के अगेंस्ट जा रहे हो, तो ठीक है, फिर आपको फ्रेश सर्टिफिकेट ऑफ इनकॉर्पोरेशन मिल जाएगा. दैट इज द ब्यूटीफुल डिफरेंस बिटवीन 252 सबसेक्शन 3. जस्ट टू क्लब 252 subsection 5, who can file application appeal? That can be filed by anyone. 252 subsection 3, only the company, member, workman, creditor. Again, company, I am not aware how they are moving it, but as per the law, company can also move it. What will be the nomenclature of the document which you will file? In 252 subsection 1, it will be appeal. In 252 subsection 3, it will be application. Limitation period under 252 subsection 1 is 3 years. 252 subsection 3 is 20 years. फ्रेश COI की बात करूं तो 252 subsection 1 में मिलेगा, 252 subsection 3 में नहीं मिलेगा. आपको अपील और एप्लीकेशन मूव करनी है तो आप कहां करोगे? ट्रिब्यूनल के आगे करोगे. दैट इज नेशनल कंपनी लॉ ट्रिब्यूनल अंडर द कंपनी. दैट इज ऑल अबाउट द डिफरेंस बिटवीन 252 subsection 1 and 3. Am I clear, आशा जी? आशा जी, am I clear? Okay, moving forward. Now grounds for revival. Suppose if you talk about the revival of company, that can happen only on 4 grounds as per my knowledge. First one will be the company is in operation. अगर company operation में है तो जो हमने discuss किया था. Second is procedure has not been followed by the ROC. ROC ने जो strike up का procedure follow करना चाहिए था, STK 1, STK 5, STK 7, वो follow नहीं करा. Third one is ROC ने जिस grounds पे strike off करा वो justifiable नहीं. Fourth one is otherwise it is just. So I will be dealing with only the red portion because पहले दो मैं बाकी जो दो है companies in operation और justifiable वाले वो मैं already discuss कर चुका. I will be dealing with two things where the procedure has not been followed and where it is otherwise just that the company's name has to be restored. Firstly, we have to understand what is otherwise just. So if referring to the Supreme Court judgment in Helen C. Rebella versus Maharashtra, it says that just denotes the equitability, fairness and reasonableness. It means there is certain reasonableness, there is certain chances that there is certain requirement, there is certain necessity that the company should be removed. And that justness, that equitability, just fairness, that reasonableness has to be ascertained from the facts and circumstances of the case. In M.A. Rahim, it was versus Sayari Bai, it was again reiterated by the Division Bench of Madras High Court that just connotes the reasonableness and something conforming to rectitude. It means there is certain equitable and fair points in the company appeal that this company's name has to be restored. Referring to the Siddhant Garg case of 2012, wherein the Honorable Court has said that you have to ascertain the particular appeal or application under 252 from the commercial point of view. Suppose, and you have to give the viewpoint to every facts and circumstances, every fact and information provided in the appeal to ascertain whether it is justifiable if the name of the company is restored, and it has to be taken in the perspective of the society as a whole. Suppose you are of the view नहीं ये नहीं होना चाहिए restore, company tribunal बोलती है नहीं होना चाहिए restore, but आपको society के point of view से देखना, अगर ये restore होती है तो society को क्या फायदा, अगर ये भी आप बता पा रहे हैं, अगर ये भी justness है तो भी आपका revival हो सकता है. Now before dealing with the important case laws, I will let you know the important prerequisites which is required to file the appeal before under 252 subsection 3 or sorry 252. First one will be the case title. You have to give the case title before the national company or tribunal and the name of the parties and all. That is the general standard format. Second, you have to attach the index of appeal. You have to attach the appeal. That will be the index book on which page number you are attaching what document. Third one will be the memo of parties. Memo of parties means the parties to the petition. Who are the parties? Who is the petitioner? Who is the petition number 1? Who is the petition number 2? Who is the petition number 3? Who are the respondents? That is called the memo of parties, in which you give the email ID, phone number, contact details of all the parties through which the registry of the tribunal may contact that particular person. That is memo of parties. Fourth one is the brief synopsis. You have to, because sometimes it not be the possibility that the honorable tribunal cannot read whole application or appeal, and they may ask you to file the brief synopsis. So brief synopsis is the standard practice which is followed before the before making the appeal or application before the NCLT. So you have to file that particular synopsis. Synopsis means the brief version of the whole application. Fifth is you have to make a particular table for the list of date of events, and you have to particularly mention that on which date what thing has happened, so that you can give the quick references to the acts done by the company or the events which has happened into the company. Then after the appeal will be there attached in the prescribed format. Now for 252 prescribed format is NCLT 9, because rule 88 says where there is no specific reference of a format has been given, the NCLT 9 format has to be observed and followed. If you refer to the NCLT rules in Hindi version of NCLT rules, they are referring to 252, but in English version, that is the drafting error again, they have forgot to refer to the section of 252. So NCLT 9 has to be the format of appeal or application whatsoever. You have to file the affidavit verifying appeal, that is filed by all the applicants or the appellants, that all the facts and information provided in the appeal are true and fair to their knowledge. So सारी appeal जो भी facts आपने information दिया है वो सब true and fair है to the knowledge of the applicant or the appellant. You have to attach certificate of incorporation. You have to attach MOA of the company. You have to attach STK 5 and STK 7. Suppose you have received STK 1
then you have to attach that also. In case you have made any reply to it, do attach it also. Consent affidavit has to be attached. That is the practice which has been being followed. That is not the legal requirement, but consent affidavit is the affidavit from the members that members are having full consent to revive this company. Even suppose tomorrow members comes up to avoid such circumstances, this consent affidavit is taken from the members and the directors. 12th one will be the power of attorney in favor of the authorized representative, whosoever it is. Memorandum of appearance. Being a company secretary, we file memorandum of appearance. Suppose you are an advocate, you have to file the wakalatnama. 14th is the document evidencing the fee. There is 1,000 fee which you have to, statutory fee which you have to pay before while making that appeal. So you have to give the document evidencing that the payment has been made. 15th is the proof of service. आपको सर्विस देना होता है. That is the rule that prior to moving any application or submitting any application or appeal before the tribunal or appellate tribunal, you have to service it to the opposite parties. So if the opposite party is ROC and income tax, you have to serve that particular copy to them, and you have to attach the proof of service here in your appeal. And 16th will be any document substantiating facts. Suppose you are having the property, then you have to give the leasehold property lease agreement. You have to give the title agreement or whatsoever. Suppose you are into some agreement or contract, so you have to give the copy of that contract. So it depends upon the case to case. It is not having any exclusive list. It can be inclusive depending upon your case. That is a prerequisite for filing an appeal. Now, moving forward. Suppose any adverse order has been given by the Honorable NCLT that they have not revived your company. They have not allowed your appeal or application. So where you can move to the higher authority, that is appellate tribunal, that is National Company Law Appellate Tribunal. You have to file the appeal within 45 days. That 45 days will be from the copy of the order of the tribunal is made available. Now the word used is not received. It is made available. Suppose so you have to regularly check over the website of the NCLT. Suppose the order has been passed and it has been made available after 2 days. Then after 2 days, that 30 days will start, 45 days will start. Suppose it has been made available later on, you have received it later, that is not the concern. If it is made available means you are having the chance to have it through any mode. So 45 days will start from there only. Suppose that 45 days can be extended for another 45 days depending upon the discretion of the appellate tribunal. You have to satisfy that there was certain reasonable grounds on which the appeal was not able to be made within 45 days. So if the appellate tribunal is convinced, so they will be moving they will be allowing you to condone the delay. You have to file particularly the application for condoning also under Rule 11 of NCLT rules. You have to attach that application separately with that appeal for getting the condonation of delay over the particular matter beyond 45 days. So that is the section 421. Now coming to the last part, that is important case laws. Now sometimes the question comes whether CIRP, corporate insolvency resolution process, can be initiated against the corporate debtor company which has been striked off by the company, which is having a strike of company. Then in the case of Hemang Pufalia ji versus the Greater Bombay Cooperative Bank and other, Honorable NCLT has given the viewpoint that yes, what was the case, that Greater Bombay Cooperative Bank Limited has filed an application under Section 7 against Penguin Umbrella Works Private Limited before the NCLT Mumbai. Section 7 refers to the financial creditor, where the financial creditor is having the due and it has not been paid by the corporate debtor. It can move the application under Section 7 of IP. Now what is the ground taken is the corporate debtor is striked off. So the application cannot be moved against. The question of law got involved in it is that whether CIRP can be initiated against CD having a strike off status. Then the Honorable NCLT has very beautifully interpreted various sections of striking off chapter of Companies Act. First finding of the NCLT, Honorable NCLT, was that 248 subsection 6 says that the asset of the company will always be made available. It will always be available for the payment or discharge of the liability. अगर कोई liability है, even if the company is striked off and the company is having assets, So वो use हो सकती है for the payment of the liabilities and the obligation. Second finding, 248 subsection 7 says that चाहे कंपनी स्ट्राइक ऑफ हो गई हो, इसके डायरेक्टर, मैनेजर और सारे ऑफिसर
तो रखेंगे
लायबल हो. हेमंत जी, आई थिंक someone is speaking. Okay, I've muted. Thank you. So suppose 248 subsection 7 कहता है कि अगर कोई कंपनी स्ट्राइक ऑफ हो भी गई है तो भी डायरेक्टर, मैनेजर और कोई भी ऑफिसर जो मैनेजमेंट की पावर में था एंड हर मेंबर will continue to be there in liability position even if the company has been dissolved. So 248 subsection 7 says so. 248 subsection 8 says that the strike off done by the ROC will not affect the power of the tribunal to wind up the company. So it means the winding up can be started by the tribunal later after the strike off, because strike off is giving the status of dissolved, but it is not liquidating it. So tribunal can tribunal can pass the order of winding up. After the winding up, official liquidator or whatsoever the provision is there, the liquidator will be appointed, that will be settling all the liabilities and will be recovering all the dues, and settle proper liquidation procedure will be done by the particular tribunal direction. So that is 248 subsection 8. 250 says that after the removal, effect of strike off, after the removal of the name of the company from the register, when this company stand dissolved, it will not be for two purposes. First one is the recovery of amount, second one will be the payment of liabilities. It specifically says so. That is the effect of strike off. So 250 also substantiate that financial creditor is having the full right to file the application. Last thing, 252 subsection 3, it says any creditor, because अभी हमने पढ़ा था चार लोग 252 subsection 3 में, company, creditor, workman and member. So creditor includes financial creditor also. So they can move the application within 20 years of companies being strike off. So they are having full right of it. So therefore CIRP can be initiated. But voluntary liquidation cannot be initiated on IBC. Voluntary liquidation का मतलब होता है आप खुद ही जा रहे हो liquidation करने के लिए, वो नहीं हो सकता क्योंकि STK 2 आपने मूव कर दिया था, वॉलंटरी स्ट्राइक ऑफ हो गया. जब भी लिक्विडेट करना होगा प्रॉपर तरीके से आरओसी करेगा या गवर्नमेंट अथॉरिटी करेगी, आप नहीं कर सकते. लेकिन आप सीआईआरपी के थ्रू अगर आपको सपोज करो रेजोल्यूशन प्लान नहीं मिलता है, देन लिक्विडेशन प्रोसेस जो है वो आपका फॉलो होगा, तब वो लिक्विडेशन प्रोसेस वो वाला फॉलो होगा. वॉलंटरी लिक्विडेशन प्रोसीजर अंडर सेक्शन 59 ऑफ आईपीसी कैन नॉट बी फॉलो. दिस इज द फर्स्ट केस. सेकंड इज, सपोज कंपनी के पास रेवेन्यू नहीं था 4 साल से, लेकिन कंपनी ने फिक्स डिपॉजिट किए हुए और कंपनी एक रेगुलर इनकम ले रही है, उसके ऊपर इंटरेस्ट इनकम ले रही है और आरओसी ने उसे स्ट्राइक ऑफ कर दिया. क्या वो कंपनी रिवाइव हो सकती है? तो द केस वाज ऑफ द मिस्टर ध्रुवराव श्रीराम केलकर and travel time cars private limited versus ROC. So in that what happens is that the company was having the fixed deposit of 1,50 lakh from Bank of Maharashtra, and which they have given as the bank guarantee also to the Atal Indore City Transport Services Limited. And on that FDR, they were receiving regular income. Also, when the STK1 was received by the company, they have filed the reply to it. But still the ROC has striked off the name. They moved the application under 252. So, Honorable NCLT found that when the reply to STK1 was made, 248 subsection 6 says that ROC should make sufficient provision for the realization of all the amount and discharge of liability. मतलब उसको इतना ऐसा प्रोविजन बनाना पड़ेगा कि वो सारी रिकवरी भी कर सके और सारा लायबिलिटी डिस्चार्ज भी कर सके उस कंपनी. लेकिन आरओसी ने वो कंप्लाई नहीं करा. इट मींस दिस इज द एग्जांपल ऑफ द प्रोसीजर बीइंग नॉट फॉलोड. सो प्रोसीजर हैज नॉट बीन फॉलोड. ऑल्सो जो कंपनी ने एफडी दी थी, एफडीआर किए थे और उस पर जो इनकम ले रहे थे, उससे शो होता है कि कंपनी इज कीन टू रन द बिजनेस. कंपनी इज मेकिंग एफर्ट्स. वो जितना पैसा है वो खाली नहीं रख रही है, वो कंपनी एफडी पे डाल रही है एंड इट इज जस्टिफाइबल टू रिस्टोर द नेम ऑफ द कंपनी. दैट वाज द फाइंडिंग ऑफ ऑनरेबल एनसीएलटी ऑन जस्ट ग्राउंड. So that was the situation where company was not having revenue, not having operation, not having business, but just the fixed deposit that was revived by Honorable NCLT. This is a very beautiful judgment. Now coming to the third point. Suppose company is not having any revenue, but company is having power plant agriculture field of power plant. Now the company is having only asset. Whether that company can be revived, there are two school of thoughts. Companies having asset that will be liquidated, that will be auctioned. The property will be auctioned, and later on the company will be standing dissolved for all purposes. But in case of VR Gopalan, who is a shareholder of Fragrant Farms and Exports Private Limited, the Honorable NCLT Chennai bench has revived this company also, because the ground taken by the shareholder was that it do not want to waste the asset of the company, because in the auction they won't be able to realize the proper amount of it. So just to want to save the asset of the company, this company requires immediate revival, restoration, and the Honorable NCLT was satisfied, and Honorable NCLT has restored the name of the company, and that was a very beautiful judgment. Also, company has said that the company is having the Honorable Tribunal has said that the company is having the subscribed capital to the tune of INR 3 lakh. So it shows that the company is having full chances to restore the business. So that's why restoration is justifiable to be done. The NCLT Chennai bench has allowed that appeal also. That is a very great judgment. Now the last judgment is, suppose your application has been allowed, your appeal has been allowed, but the Honorable NCLT has imposed a cost of 5 lakh rupees, which is a huge cost. So whether you can argue before the Honorable NCLT, you can appeal against that particular portion of that order, that this fees, this cost which has been imposed is quite high, then the answer is yes. In the case of Rajendra Suresh Bhumkar versus ROC, the Honorable NCLT has said that the appellant has made a very good case in the appeal. They have given all the great points which can justify that their company should be restored. And on being so justifiable, imposing such high cost is not a correct way to look into the appeal. Is not a correct action. And Honorable NCLT has very gracefully removed whole cost of 5 lakh rupees, and the company's appeal was allowed without any cost. So that was the great achievement of the I would say the company, because the company has saved a cost of 5 lakh rupees. So that is all from my side on the topic of strike off and revival. If there is any question, I would like to answer it. Asha ji, if there is any question, I would like to answer it. This is my contact credential. Persons may also contact me in case of any query. Yes. Is there any question?
Thank you very much, Santoshi. Request our participants कि उनकी कोई भी query है तो they can ask their queries, or even they can raise their hands अगर one to one if you want to ask anything.
एक चीज मैं ऐड करना चाहूंगा, सपोज अगर
Yes, please.
बिजनेस भी नहीं है लेकिन कंपनी ऑपरेशन, बिकॉज कोविड टाइम पे क्या हुआ था कि कंपनीज काम ही नहीं कर पा रही थी, दे वर डूइंग वर्क फ्रॉम होम and they were not having any business, they were not having any single penny of revenue, and that company was not also able to do any operations. Suppose that company receive STK1, and today that company having the intention to restore and to do the business in the future, that company can make the reply to STK1 or STK5 that they are intending to do the business or operation. So request you to kindly not to strike off the company. On that ground, ROC can also not strike off the company, because ROC should have the reasonable cost to bleed again. So that is all from my side. If there is any query, I would love to answer it, Asha ji, and I hope the participants have been benefited by the presentation. Hope I am able to justify the topic.
Yes, sir. In my opinion, it was very well explained. And queries as of now नहीं है हमारे पास.
Online mode में कमी आती है. Correct. Yes.
Hemant ji.
Thank you, Santosh ji.
Thank you, Hemant ji. Thank you.
Such a wonderful presentation, and I hope all the participants will gain knowledge from this deliberation. And I thank you all the participants on the behalf of Laxmi Nagar CPE Study Circle. And I hope, Santosh ji, next time we will meet at Crystal Banquet for physical seminar.
Physical programs are always good.
Yes.
So we are also expecting.
सर अभी हो क्या रहा है, जो इंस्टीट्यूट फिजिकल करा रही है ना, उसमें भी इशू ये आ रहा है कि नंबर्स नहीं आ रहे हैं।
राइट।
सी इंस्टीट्यूट वाले भी नहीं आ रहे, क्योंकि क्या है, जब से वेबिनार आ गया ना, अब ये ऐसा सिस्टम हो गया है कि लोगों को नॉलेज भी मिल रही है,
आदत पड़
अवर्स
गई।
भी मिल रहे हैं, तो जो आने वाला time है वो बचता है।
पर थोड़ा
आदत
ईयर
कोशिश करेंगे
क्लोजर
हम
का भी, ईयर क्लोजर का भी एक अपने आप में है इशू
यस।
कि
अब एक बार करके देखिए फिजिकल, अगर लोग आते हैं तो फिर फिजिकल पे शिफ्ट हो जाएंगे, नहीं आते तो सर फिर वेबिनार ही करेंगे।
फिजिकल प्रोग्राम हमारे यहाँ पे भी होते हैं, तो हमारे यहाँ फिजिकल प्रोग्राम्स में सारे मेंबर्स आ रहे हैं, सो वी आर गेटिंग गुड ग्रेट सक्सेस ऑन इट। So it will be great if you can organize physical program. It will be really nice to interact with you.
यस
ये
यस
करेंगे,
डेफिनेटली।
करेंगे। ठीक है, थैंक यू आशा मैडम,
थैंक यू,
Thank you,
थैंक यू
Asha ji.
संतोष जी,
Thank you so
थैंक यू
much,
सो
Hemant
मच,
ji. Thank
थैंक
you,
यू
Lakshmi
ऑल,
Nagar CPE and all the. Thank you so much.
थैंक यू ऑल द पार्टिसिपेंट्स।